SARS Advocate Jeremy Gauntlett has responded scathingly to Jacob Zuma's affidavit, in which the former president confirms that he tweeted concern for his tax information to be handed to the public protector. If admitted, Gauntlett says Zuma's affidavit destroys the public protector's case to subpoena SARS to hand over the records. The Pretoria High Court is hearing the application brought by SARS to limit the powers of the public protector in relation to her power to access confidential tax records. For the latest on this story, I'm joined now in studio by our editorial contributor, Karyn. Maughan. Karyn, it's good to have you with us.
Thanks for having me.
So it's a matter that's been going on for a year now, and really, 2018, 2019, SARS tried to speak to the public protector and explain that, as far as we're concerned, Tax Administrative Act does not allow you. There are a couple of institutions that are cited. Also, even there, SARS would have to use its discretion in terms of the information that is given. But the Act just doesn't allow a third party to access information that has got to do with SARS investigation. Of course, they were slapped with a subpoena in November, and now they are taking this to court. And the main challenge here is really not about the individual Jacob Zuma, but it's really about you and I also as taxpayers, isn't it?
Well, essentially that is what SARS Commissioner Edward Kisvete is arguing. He says that this whole issue has got profound implications for taxpayer confidentiality. And he says, you know, SARS' ultimate responsibility is to ensure that they can collect revenue. And if people fear that, you know, their information may be made available to other bodies in circumstances where, you know, it's not necessarily appropriate for that to happen, they may not be as forthcoming with certain information as they would want to be. And, you know, ultimately, it's so interesting that we find ourselves in this situation, because when Jacob Zuma was first prosecuted for corruption, SARS was immensely reluctant, then under the leadership of Commissioner Pravin Gordhan, to just go along with a prosecution for tax evasion linked to the evidence led in the Sheikh case. And, you know, it was only after, you know, because Jacob Zuma settled his tax issues with SARS at that time, and it was only after the former president was charged under the Prevention of Corruption Act that SARS actually agreed to assist in some way with the investigation. So this is not a new thing, and we know that SARS has an attitude that if people are prepared to disclose, come forward, whether or not those activities may be legally questionable or whatever, their ultimate responsibility is about ensuring revenue collection. It is only when they become aware of tax evasion that's linked to criminality that the game changes somewhat.
So it seems 4 months later, after the fact, President Jacob Zuma has decided to officially put in an affidavit, much to the surprise of the public protector, because I don't think she expected it either, but it throws a spanner in the works as far as her challenge is concerned.
Well, it's a very interesting thing, because her lawyers, you know, she had gone on affidavit and said, look, you know, this whole application by Kisvete may actually be academic, because look here, former President Jacob Zuma, in the wake of Kisvete's, you know, press conference saying he was taking this legal action to get an order that, you know, the public protector's subpoena powers do not extend to SARS information. Zuma's Twitter account comes out with 4 or 5 different tweets basically saying, you know, I don't have a problem, we must cooperate with the public protector, etc., etc. Maughan then puts that in her response to Kisvete's initial application, says, look here, you know, he's agreeing with this, he has no problem, so not really an issue. Kisvete then hits back and says, how do we even know that these are Jacob Zuma's tweets? You know, like, you know, it could be anyone. Exactly. So then he's like, and Jacob Zuma's not opposing. Jacob Zuma said nothing about this. There's no confirmatory. And then yesterday, on the eve of today's hearing, the former president filing a 4-page affidavit in which he says, look, I have been in a very serious health condition. I have been getting treatment overseas. I was aware of this, but my health situation and my travels, etc., prevented me from filing this affidavit. Jeremy Gauntlett for SARS having none of it. I mean,
let's take a break, Karyn. I want you to stay on, because I want you to explain exactly why is he taking a serious exception to this particular line of an affidavit that was brought on by the former president. Let's take a break. We'll continue after this. editorial contributor Karyn with me now this evening is, of course, the battle between SARS and the Public Protector continues. Judgment reserved until the 23rd of March. So this 4-page affidavit, Karyn, has really thrown the spinner in the works, and scathingly so. The advocate representing SARS, Gauntlett, is having none of it.
Well, I mean, he brought a full-pronged attack, because remember, this thing was filed yesterday, so on paper there was no real, and the public protector, yes, his own spokesperson said, she was not expecting this. She didn't have any kind of warning that this was going to happen. So I think both sides of this whole thing being quite surprised by it. But Gauntlett essentially saying, first of all, it's not properly before the court. You can't file something 4 months after the deadline and then expect the court to accept it. There's no proper application. So on a technical legal level, we just don't think that this even qualifies as evidence. But if it is evidence, if it is admitted, it actually destroys, that was the verb that he used, the public protector's case, because she then why does she need to subpoena information where there's now clear evidence that she hasn't gone to some of the parties involved and actually tried to get that information?
So that is what the affidavit says. Jacob Zuma says, if you had come to me, I would have given you that information.
No, it doesn't say that. And that's what Dali and Porfel responded. He said, no, this isn't Jacob Zuma saying, I'm going to hand over this stuff. It's just a confirmation of the tweets, which is that he doesn't mind the information being handed over to SARS. Also remember that there's a whole range of information that Mkhwebane is asking for. It's not just Jacob Zuma's tax returns. It's the investigations that may have been revolved around the alleged 1 million rand monthly payments that he is said to have received in the first few months of a presidency, which then DA leader Mmusi Maimane was concerned he didn't declare to Parliament. He's saying, that there's a range of information here, and this is not about, we don't even know if Zuma has this. He's not there to the court saying, to quote Dali and Porfel, look at this information that I have in my cupboard, in my wardrobe, let me just hand it over to you. He's saying Zuma is consenting to that information being handed over by SARS. So therefore, it doesn't destroy our case. We still need to use it.
It's Section 70 of the Tax Administrative Act that in essence says certain entities that SARS would now and again have to interact with may ask to be given information. One is that the public protector is not one of those persons listed there, but also there are certain conditions in which SARS can give this information away. For example, if the person whose information or the taxpayer gives consent, but even then SARS can hand over the information of the taxpayer but not their own investigation.
And that's the very important point, because Gauntlett was arguing that, because the public protector was asking SARS for certain statements about their investigations, if there were any, that was inappropriate, that actually went way beyond the bounds of any, potential thing that she could subpoena. Also an interesting point, Dali and Porfel made a lot about the fact that one of the bodies that can obtain information from SARS, apart from the Auditor General, is NSFAS. And he said, how could it be that a student bursary scheme can access information from SARS, but the public protector, as a watchdog against corruption, cannot? Gauntlett then responds and says, well, what information does NSFAS get? They can confirm the addresses of SARS, can confirm the addresses of certain students, but that's the extent of it from SARS. So it's this kind of far-ranging interrogation of the public protector's subpoena powers, how far they go, and whether or not she is, as she argues, constitutionally empowered to get this information from SARS, and that because she has these constitutionally based subpoena powers, therefore her subpoenas trump the provisions of the Tax Administration Act, which of course Kisveta says is simply not the case, that for him to simply provide this information without a court order ordering him to do so would in and of itself be a criminal offence.
And of course, Jeremy Gauntlett arguing that it seems the public protector thinks she's got probably top of the powers when it comes to other section, what is the section?
Yeah, Chapter 9
Chapter 9
institutions.
I beg your pardon, it's a Section 9 institution. Chapter 9 institutions.
Well, this was the interesting thing, and I put that question to Opa Sakalwe, who is the spokesperson for the Public Protector, and he said she doesn't see, the Public Protector doesn't, in his words, doesn't see herself as being way above everyone else, but he said she sees herself as being slightly above everyone else. And his argument and her counsel's argument, which he pointed to Dali Mpofu's argument, is that, for instance, in the case of the Public Protector, because of the Gauntlett judgment, her remedial action is binding unless it's taken on review in a court of law. And that's where she's making her argument. She's saying a lot of these other bodies, the Auditor General, for example, can make recommendations, but his powers have been subsequently toughened up by the Ramaphosa administration. But a lot of these Chapter 9 institutions don't, or those kind of institutions within government, can make recommendations, but they can't force government to do what they are recommending. Whereas the Public Protector, thanks to the Gauntlett judgment, can do that, and that's really one of the primary bases of this argument. Mpofu was referring to Gauntlett throughout this hearing. Ironically enough, of course, Jeremy Gauntlett represented Zuma in that case. So there was a bit of to and fro about the matter. But essentially what she's saying, I've got this constitutional power which elevates me slightly above these other bodies, and therefore means that my kind of subpoenas and ability, attempts to get information are more profoundly legally pressing than other entities.
Either way, very interesting case, because it has far-reaching, of course, consequences, even for the sitting president, doesn't it not?
Well, I mean, if there is a situation where the Public Protector, it becomes a kind of settled law that she doesn't need to go to court in order to access other people's tax records and confidential tax records, then there is absolutely no basis to stop her from using those powers into the future on other people, including the former president, who, has these question marks, according to her, over his campaign funding, etc., etc. So if there's an executive ethics complaint made against President Cyril Ramaphosa in terms of non-disclosure or etc., those kind of allegations, the Public Protector would be completely emboldened within the situation to go and ask. And she says she should be able to do that. But crucially, next week, we know the same High Court is handing down its judgment in the case involving Ramaphosa's challenge to Busisiwe Mkhwebani's report on his CR17 campaign funding. She, of course, averring that he may have been implicated in money laundering. Crucial judgment next week to see if he's successful in that challenge.
All right. Karyn, appreciate your time. Thanks for coming through. Meanwhile, of course,